the dawn of democracy in 1994, the Prisons Department was changed to Correctional Services. This was done to show that prisoners can be changed and rehabilitated. The focus of prisons is ostensibly reform and rehabilitation, but it appears this is not happening, as evidenced by the high number of repeat offenders. Let's discuss this with legal expert Mpumelelo Zikalala, who joins us now virtually. Mpumelelo, thank you very much for your time here on eNCA. Of course, some of what Minister Ronald Lamola said in his answers to questions posed by those in Parliament was quite shocking when it comes to reoffenders. But of course, the team and I were discussing, where does a victim go when they suffer a crime from someone who is out on parole? Where do you go? Do you sue the state?
You can sue the state, but it will depend on the causal connection between the judgment of the state and the events that have already occurred. Just remember, there's a duty to care by the state. I think the commercial case is very clear on that one, which was decided in 2001. But it then says the persons or the individuals which have selected as a parole board have got a certain duty to carefully assess whatever applications that come in front of them and to properly monitor whatever the actions of the offender would then be. Let's remember that as per the Correctional Services Act, the mere fact that a person has been released on parole does not mean that the sentence which was given to them at an earlier stage has now been extinguished. It simply means that you are serving your sentence in a different form, in a different format, in a different venue compared to you being in prison. So you still need that particular level of duty to be applied by the Correctional Services officials to make sure that you do not repeat offend or that you've really changed and you're not putting a facade when you made a particular application. But I think it must go back again, which is why it's correct, why we should pose this question to the minister in terms of saying, let's look at the individuals in which you are appointing as the parole board members. Do they have the adequate support? Is there a particular enough time to do the actual assessment so that at the end of the day you make the correct decision? If there's a high number of repeat offenders, definitely go back to the drawing board and say, we must do this parole investigation process in a different manner because we are going to be sued at a later stage. I think it would only take one or two matters similar to the commercial case to change the whole manner in which this particular board is working.
Mpendula, I don't know if you remember the case of Bontle Mushiane in Limpopo. The person who actually is now facing trial or a court case in that particular case, one of those men is somebody who was a reoffender. So he was released the first time, he reoffended, and then released the second time and reoffended. So in a case like that, where somebody who's a parolee reoffends twice or more, do you not have grounds to say to Correctional Services, when you granted this man parole, you knew that he had reoffended before and you still let him go?
Definitely. Those are the individuals in which we'd go back and sue. In fact, we'd go back to the parole board and say to them, you have a duty to protect my interest, especially as one of the accused or even as general members of the public. In your assessment, you failed in your duty to apply reasonable care, to use your skills and knowledge and experience to make sure that you're able to assess this type of things easier. Now, it would baffle me as to why a repeat offender would then be given a parole, because that particular individual has clearly showed you that their conduct has not changed at all. There's no correction that has taken in the Correctional Services. So why would you go through a particular process? So I think going back and saying to the parole board, I need those records. I need the minutes. I need to understand who said what, when, what was the questions which were being asked, what type of documents did we then assess, and what caused you to reach this particular decision. When that matter goes to court, the court will ask themselves this question: would a reasonable parole board member have taken a decision to release this particular individual had they known the information that they have at their disposal? If the answer to that is yes, then they would be absolved of any guilt. But if the answer to that is no, that means they failed in their duty of care. So as you have perfectly put it, a person who is a repeat offender, in fact, it's the third time now in which they would have gone out and then done something which is clearly showing that they have no intention whatsoever of changing. At the end of the day, whoever ticked that and signed that particular release form must be found guilty of delegating their duty to care.
And of course, in this instance, you wouldn't necessarily be suing the police or taking, your legal papers against, the respondent wouldn't be the police minister, for instance. It would rather be the Justice and Correctional Services minister, right, or the Correctional Services department. But if you look at the fact that there are people who, for instance, don't even know that they have these rights to be able to even ask the parole board for these documents, etc., it shows, how little South Africans know about their rights.
Definitely, and I think it must be some type of awareness which must come, especially from the Correctional Services Department, and then moving on to lobby groups like your Black Law Association and NADEL and any other civic organization that is there, in terms of saying even us as legal practitioners, let's extend our services to make sure that justice is found for those victims in instances where the parole boards have failed to do their duties in an optimal manner. But it again comes back to the minister, for example, in terms of saying you are in charge of making sure that this department is working optimally. If you are going to present reports which are unfavorable and shows that somewhere, somehow, someone is not doing their duties, it falls upon you and your responsibility to then come back and say, let's go back to the drawing board. The easiest thing to do is to place a list of requirements which are going to make it so onerous for one to slip through the fingers of this particular assessment. Because at the end of the day, I know that as a department, I'm going to be sued, and it's the taxpayers' money which is going to go and compensate the victims. So let's prevent those issues by making sure that we do our in-house issues carefully, and then we comply with the law.
Mpumelelo, I'm interested to know your legal opinion, looking at the fact that the period to which this is spoken about, when there were about 300 and something repeat offenders, or more than 300 crimes actually that were perpetuated by repeat offenders or parolees. It coincided with the time when we were told by international organizations such as the WHO, etc., to let go of a few prisoners to ensure that we have less crowding in our prisons, because we were going through a very bad pandemic and it was vile during that time. So the president obviously then, addressing South Africans and telling us that there would be parolees from May 2020 who'd be released, right? And then you see some of them reoffending. So does the scope then become bigger in terms of who you sue? Do you take it straight to the presidency? Is it their fault? What do we do? Especially because they got advice from an international organization to let go of quite a large number of offenders.
You can add as many participants as you want, but at the end of the day, the court will then come back and say who has a duty to care in this particular instance. And it is the Correctional Service. You may have received a direction from the president, for example, unless someone is being let out on a presidential pardon. But other than that, if the president says to you, please go and assess these particular individuals, you go back to the Correctional Services Act, you go back to the best practices that you've been using all this time, and you exercise your reasonable care and skill as the person who's been given that particular responsibility when assessing each individual case. So if you're going to go back and use COVID as a blanket approval rate of saying that there was COVID which was taking place, there was a pandemic, and maybe we didn't apply our minds in a manner in which we ought to have applied to, that's a delegation of duty. That's the duty in which we are talking about, that you ought to have applied your mind in a proper manner. You ought to have used your skill and care to make sure that you are preventing these type of offenders from going back, because the repercussions of that is that you now have more victims of crime. You have more people that have been affected by your negligence when approving or granting someone parole when they shouldn't have received parole in the first place. So you can include as many participants as you want, but the court is going to zero down into the legal duty aspect and says, whose job is it to press the green button? Let's look at that individuals and check whether, when pressing the green button, did they check all the elements, approve all the compliance checks that needed to be there? If they didn't, then they delegated their duty, they should be punished.
All right, Mpumelelo, thank you very much for your time here on eNCA. Always a pleasure. Mpumelelo Zikalala from Zikalala and Associates speaking to us there from Durban.